Thank you. Good morning. My name is Colin Weatherall. I'm the chair of the DLC hearing committee. With me this morning, I have RJ on my left and Karen on my right. They're appointed members of the DLC, and we're prepared to hear the application with regard to New World Gardens, 6 North Road, Dunedin. Just let me do a little bit of housekeeping first. The staff we have with us are GSO is Lynn Adamson, and our DLC secretary is Kevin Meacham. The applicant, would you please introduce yourselves as an applicant, please?
Yes, good morning, members of the committee. My name's Ian Thane. I'm counsel for the applicant, and I'm here with Craig Broderick, who is a director of the applicant.
Thank you, sir. The agencies, please, Mr. Mole, or DLC licensing.
Yeah, Tony Mole, licensing inspector.
And would you like to introduce the witness you're going to call, just so we have a record?
Yes, we have Nicky Jackson, Dr. Nicky Jackson from Alcohol Health Watch.
Thank you. Police. Sergeant Jones.
I think Sergeant Steve Jones.
Thank you. And as an apology, am I correct, from Public Health South? Health and safety matters have been covered by the committee internally. Obviously, it's affecting us that are in the room. The hearing this morning is a novel one, I guess, for us in many ways, taking it on Skype. But the hearing will be recorded separately as required by the authority to ensure that we have a transcript available. This case, I guess they have a choice to vote. Skype protocols will be handled by RJ for me. So if you want to grab his attention, it's either a hands up or indicate physically that you'd like to talk, but it's just as we work through the process. The process will be the applicant's presentation, and then will be crossed by the committee and then by the agencies. Procedurally, I'll take any questions in a moment if there are procedural matters, and then we will invite Mr. Mole and Dr. Jackson to present their evidence to the committee. A cross can be, of course, by the committee, again by the applicant, and other agencies in the room will be able to cross-examine as well. Following that, we have applicant's right of reply. Agencies have a review for the committee of their summary of the events to date, and then any final questions from the committee or clarification. I won't predetermine where the committee will go in the final part, because a number of options are available to us. Let's just address those when we reach that stage. The intention will be to go through this morning for perhaps an hour and a half. Let's just see if we need to take a short adjournment at that point. Otherwise, we'll just mark progress as we go, but there are a few matters to go first. Procedural matters. Applicant, have you got any procedural matters you wish to raise with me?
Not at this stage, sir. There are some housekeeping matters that I'll address you on just as I start our opening presentation.
Thank you, John. Mr. Mole?
Yes, I have a significant procedural matter, sir, in the fact that the applicant failed to meet the committee's requirements for disclosure, and I have been, in a sense of procedural fairness, I seek that the meeting be adjourned to a further date so the information, the evidence presented by the applicants can be assessed correctly. I have not had the time to look at the two evidence presented. One was presented at 3:24 yesterday and one at 7:38 this morning, and I think that's completely unfair to drop that on me at this time.
Sergeant Jones, I realise you're not a submitter, but do you have any procedural matter? I'll come back to you. Sergeant Jones, all clear? Okay, let the committee adjourn for a moment on Mr. Mole's request. But does the applicant have any submission for us to consider, having heard Mr. Mole's objection procedure?
I'm sorry, sir, it was hard to hear then. Were you asking to hear from the applicant in relation to Mr. Mole's request for an adjournment?
Yeah, I think that's fair for the committee to invite your brief summary before the committee of chairs to consider his request and then decide. We're going to allow him to burn outside the window here by the sound of the chatting away. But I think it's fairness, open fairness to you to have any brief comment you wish to make.
Yes, so the applicant opposes that request for an adjournment. The evidence that's been served yesterday afternoon and this morning is of fairly narrow scope, as the whole matter before the committee is of fairly narrow scope. As you know, there's no objections to this application, and the only opposition that's been filed is by Mr. Mole, and it only seems to relate to one particular issue, which is the issue of what he describes as low-cost, high-alcohol beer products. And he's identified 6 of those. 4 of those products, the applicant has already voluntarily agreed not to stock any further. So we're dealing with a fairly narrow issue. And the evidence that was served yesterday and this morning largely just covers other matters in relation to the suitability of the applicant, things about the applicant's systems, staff training, etc., just so that the committee is aware of that material, and then just provides some detail of sales volumes for the particular products that Mr. Mole has set out. But what we have not done is seek to respond in great detail to all of the many, many pages of material that Mr. Mole served less than, I think, 2 weeks ago from Dr. Jackson's evidence. So in my simple submission, the committee is going to be in a position to deal with the matter today, or at least to well advance it. Even if it became apparent at some point that an adjournment would be helpful, that point is not now. It would be best to proceed with the matter now.
Thank you, sir. Lynn, can we get Paul to take us out, please, for a couple of minutes?
Just ask Paul, tell Paul you go.
Paul, can we just get you to adjourn the hearing for 5 minutes maximum? We'll give you a notice when we're coming back in. the counterbalance from the applicant. The committee have received the information in the same timeframe Mr. Mould talked about. We have had the opportunity to read it, but we have formed no opinion on that. We believe that we are much better to listen to the applicant's presentation and continue, and then reconsider the point we're at. Perhaps there's two steps in it. When we come to the presentation by Mr. Mould, we will give him an opportunity to perhaps place that record back on request, or again, further down the hearing, because I'm not going to predetermine what the committee's choice is as it goes ahead anyway. We've got some steps in the process, and we need to take those. So the decision of the committee is to continue at this point, but we will reconsider the request later in the hearing. Mr. Mould.
I strongly protest about that decision, sir. This procedurally is unfair. I complied fully with the DLC's practice note on disclosure. The applicant has not done so. I have not had the opportunity to read the two submissions, the two bits of evidence submitted at 3:24 yesterday and 7:38 this morning. I strongly protest. I think procedurally this is particularly unfair, and if we're going to have a practice note, then what's it for? We either adhere to it or we don't.
Mr. Mould, the decision was made by the committee. We are going to continue and take the applicant's evidence this morning. Your protest is noted, but there is no disadvantage if we consider at the end of the applicant presentation of where it is. You have a cross-examination opportunity, you have a presentation opportunity for evidence, and each of those will give us an indication of the state the hearing is at. Mr. Mould.
How can I cross-examine something on evidence which I haven't had the opportunity to assess?
I have said to you, the opportunity will be at the end of the applicant's presentation. You will be of benefit to hear the applicant's presentation like the committee will. So I'll reassess the call at that point. The committee will probably have their questions, but the agencies have an opportunity to cross-examine. And that's the point, the next step in the process. The timing is noted, but the committee have read them, the documents, and we are reminded to receive them and listen to the applicant's presentation this morning. So that is the call. So now invite the applicant to present their application.
Apologies, before we move into that, just as another protocol for the Zoom meeting, can all participants please mute their microphones whilst they're not presenting, just to ensure that we eliminate background noise, and if you wish to raise a point, as Mr. Mould is doing, either raise your hand physically, or there is an option within the program to raise a virtual hand as well. Mr. Mould?
The sound coming from the committee room is particularly poor. I'm finding it difficult to hear anybody in that room.
I have to take the mask off when you talk.
It's not a mask issue.
Well, it's a standard council process, Mr. Mould, you're well aware that we're using. We've got supporting microphones available to us. If you require technical support, I'm happy to take a moment or two and see if we can have that clarified.
Are the other participants able to hear us?
Yes.
Yes, we can. It's not the clearest of sound. It's not obviously as good as if we were able to be physically present in the same room, but we can hear. And to the extent that anything's unclear, we'll ask for clarification.
Thank you. Mr. Mould, do you want a moment to let Council IT have a look at your service or support?
No, I'll just try harder.
There are headphones available, I'm sure, if you prefer to pick those up as well.
No, it's okay.
Okay. All right. Well, before I invite the applicant, Mr. Meacham, to give an overview of his report and to remind all the parties you've been advised with regard to the declarations to be done, the oaths to be done before you present evidence. Mr. Meacham, please.
Good morning. This is an application by Basnev Limited for a new off-licence for the premises situated at 6 North Road, Dunedin, and known as the New World Gardens. The applicant is experiencing the operation of such premises. The application was publicly notified and attracted no opposition. The Medical Officer of Health and Police did not oppose the application. The licensing inspector has opposed the application because of concerns regarding the sale of high-strength beers and single units at low cost. The inspector believes this is contrary to the object of the Act and questions the suitability of the applicant.
Any clarification from the committee of Mr. Menson's overview?
No.
Right, applicant, please, I'll get you to take the oath. RJ, I'll just take you through that as before we start the presentation.
Just to confirm,
There's a delay. I've got to come off.
and do you have a declaration that you can provide for Mr. Roderick's presentation, or will you be presenting evidence of truth?
Well, I'm counsel for the applicant, so I'm only going to be making submissions. I'm not giving any evidence myself. Mr. Broderick will give evidence, and he can take a declaration or oath as you require. And Mr. Sullivan is the other witness for the applicant, and he also can do the same. He's in another location, and hopefully we'll be able to get some good internet. But certainly I'm only a lawyer. I'm just going to be making some submissions.
Thank you. Did you receive the oath?
Yes. Yes,
Yes.
I have that in front of me.
If you could make that oath or affirmation for the committee, and then we can proceed with open presentation.
Shall we do that now, or shall we wait until we start with the evidence? Because it may be that we're best to have Mr. Sullivan's evidence first, just so that we can get him, because his internet's a bit patchy today. So shall we do the oaths and affirmations at the time that I call the witnesses?
Yeah, sure.
So with your leave, Mr. Chair, shall I begin on just outlining the applicant's position?
Thank you.
So firstly, just that housekeeping matter, you will have received, well, I understand that you have obviously received the statements of evidence from Mark Sullivan and Mr. Broderick. Those are the only two statements of evidence that you should have received. And having read them, you will have seen that Mr. Broderick is a director of the applicant, and he is the foodstuffs approved owner operator for New World Gardens supermarket, having recently purchased that store from the previous owner. Mr. Sullivan is general counsel within Foodstuffs South Island Limited, so that's the franchisor for the store. It's an application for a new license only because Mr. Broderick's company has purchased the store from the previous owner. That's the only reason a new license is being applied for, because of the change of ownership. The store itself has been licensed for a long period of time, and the applicant now seeks a new license on exactly the same terms, no change to hours or the single alcohol area or anything else. There's obviously, as you will know, no onus of proof on the applicant. The exercise is an evaluative one for the committee. There's also, of course, no onus of proof on any other party on the reporting agencies. It is an evaluative matter for you to listen to the material and make up your own minds on whether or not the applicant is suitable to hold an off license for the supermarket. And that is, as I understand it, the only issue before the committee. That's the only issue that's been raised by anybody. There's no objection at all, and only one report in opposition from Mr. Mole, the inspector. No opposition from the police or the medical officer of health. And the opposition from the inspector is focused solely on what he describes as high alcohol, low cost beer products, which he says the sale of those in the store affects the suitability of the applicant to hold an off license. There are 6 products of concern that the inspector has set out in his evidence. That's at paragraph 23, I think, in his evidence. Of those 6, the applicant has voluntarily, in good faith, agreed not to range 4 of them in the future. Stocks have been running through, and once those stocks are finished, those 4 won't be in the store. So we're down with 2 left. One of those is a product that sits in foodstuffs A range, it's described as, which means a range of products that Foodstuffs expects its New World franchisees to put on their shelves, to include within their range. That's because as a branded New World store, customers expect to receive a consistent shopping experience in terms of range and quality as they would receive in any other New World branded supermarket. So there's a range of products, not just alcohol products, but a range of products across the full range of types of product that supermarkets sell, which New World stores are all expected to include. And one of the 2 beer products that Mr. Mole is concerned about is within that A range. The other of the remaining 2 products that are that Mr. Mole has raised concerns with, Mr. Broderick is willing to consider what he does about that product going forward. But we say that is a matter for him to consider. And the fact that he is considering it does not make him unsuitable to hold an off license. Now, in relation to both those 2 products, the 2 products left that Mr. Mole has raised a concern about, we note that they don't sit below the threshold that Dr. Jackson's evidence identifies for what she considers to be low-cost alcohol. Specifically, she in her evidence talks about $1.20 per standard drink. One of the 2 products that Mr. Mole is concerned about, in his own chart, the pricing is above that $1.20 per standard unit, and the other was only below it in Mr. Mole's chart because at the time it was on special. At its regular price, that product sits above $1.20 per standard drink. Mr. Mole, in his evidence, refers to the Two Brothers decision from the Alcohol Regulatory and Licensing Authority. With respect, that decision related to quite different circumstances than the current case before you. And we say, therefore, it's of limited assistance for you. The Two Brothers case related to an application for a license, for a renewal of a license for a liquor store. Of course, as you know, liquor stores can sell spirits and RTDs, which supermarkets cannot. In the Two Brothers case, the applicants were held to be unsuitable to hold an off license, but that was primarily because the applicant was involved in illegal employment practices. The applicant had inadequate systems and training to give the committee and then the authority confident that the applicant in that case would be able to comply with the law. and the applicant in that case had particularly poor record keeping. It was also an application for a liquor store license in Tukaroa. Although the decision from the authority doesn't set out the detail of Tukaroa, it does describe the Tukaroa area as being one of severe deprivation. And if any members of the committee have any knowledge of Tukaroa, which incidentally is the town in which I grew up and went to school, it's certainly quite a different town than Dunedin City. The population of Tukaroa's severe deprivation is not similar to the student population situation in Dunedin. So for all those reasons, the two brothers' decision is not in any way determinative and doesn't really add a great deal for your current consideration of this present application. All things considered, we've got a supermarket in our current case, so limited to beer, wine, and mead, with a statutory limit on the alcohol content for those types of drink at 15% that the Parliament set, with a restriction to, and with rules that prevent the supermarket from advertising its alcohol products on the exterior of its building. And of course, it's also subject to the Act's restrictions on irresponsible promotion. The supermarket cannot promote deep discounts of alcohol outside of the store. The applicant is an experienced owner and operator of supermarket businesses with an unblemished record from many years of operating those stores. Mr. Broderick is one director of the applicant. His wife is the other, and she also has a long history in licensed businesses, and it's a good history. There's nothing from the history of either of the directors or the applicant company itself that should give anyone cause for concern about suitability, and indeed, no such concern has been raised. And we're left with two products, one of which the store is effectively obliged to carry, and both of which do not meet the definition that Dr. Jackson has put for low-cost alcohol. So taking all of those matters into account, the applicant says there ought to be no real issue around the fact that it is suitable to hold the off-license that it applies for. As I said, there are two witnesses, Mr. Sullivan and Mr. Broderick, and that's where, with respect, I submit we should go next, is to call those witnesses. And I think because of Mr. Sullivan's timetable, it might be best to call him first, if that suits the committee. And what I would suggest, if you are happy with that, is that we have a very short break for me to contact Mr. Sullivan and make sure that he can connect in, and then we can start with him.
Thank you, sir. That's perfectly acceptable. Paul, the administrator, I'm just getting him back online. Thank you. We reconvene, continuing with the applicant and going to invite the witness Mark Sullivan to present, but we're back in the applicant's hands. Thank you.
Good morning, Mr. Sullivan.
Good morning.
Now,
Can you
Mr.
hear me?
Sullivan, we can hear you, but we can't see you. Is there a reason for that?
Probably my technical knowledge. Hang on. Okay.
Thank you, Mr. Sullivan. Now, I understand that where you are, the internet may not be very good, so we'll let you know, or the chairman will let you know if your sound starts to break up, in which case we might ask you to turn off that camera, perhaps in order to maintain a strong signal, but we'll see how we go.
Okay.
Mr. Sullivan, do you have a copy of your statement of evidence with you?
I do.
Mr. Chair, I'm imagining that you would now like Mr. Sullivan to be administered the oath or affirmation.
Yes, please. Yes, please. Mr.
So
Sullivan, we've got a copy of that in front of you.
He does not have a copy of it with him, sir, so if that could be administered by the committee, that would be helpful.
That's fine. That's okay, thank you.
You got that, yeah.
So will you administer it, or how will you proceed?
I can administer the oath or affirmation.
Thank you.
Mr. Sullivan, do you provide an oath, or do you do a general affirmation making statements and evidence?
An oath is fine.
Do you, Mark Sullivan, swear by the Almighty God that the evidence you are about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir.
Thank you, gentlemen.
Mr. Chair, I anticipate or understand from your comments earlier today that you would like Mr. Sullivan to read his statement into evidence. Is that correct?
Summarise is what I prefer, but noting the length of the statement, I'm in your hands to take it either way. I don't want to lose any impact or reference, because it's 26 points. I'm quite comfortable with 2.5 pages to have it read.
Okay, I'm perfectly happy to. The only issue was whether you would take it as already read or whether you'd like Mr. Sullivan to read it. It sounds like best if he reads it.
In this occasion, that's fine. Thank you.
Thank you, sir. Mr. Sullivan, could you read your statement into evidence, please? Just start at the beginning.
Certainly. My name is Mark Sullivan. I am Legal Counsel, Company Secretary for Foodstuffs South Island Limited. Foodstuffs South Island Limited, which I'll refer to as Foodstuffs going forward, is a South Island-based cooperative whose members in general own and operate a grocery, liquor or convenience store. Foodstuffs is franchisor in the South Island for the Pack and Save, New World, Henry's BWS, Raywood Fresh and On The Spot brands. The applicant, Basniff Limited, is a franchisor of the New World brand and operates New World Gardens, which I'll refer to as the store, in Dunedin. The applicant took possession of the store on the 1st of November 2021 and has applied for a new off license for the store on the same terms as the previous owner's off license. The police and medical officer do not oppose the application, and I understand there is no public objection to the application. However, the licensing inspector has reported an opposition to the application. I've read the inspector's evidence and make this brief of evidence in reply on Foodstuffs' engagement with the inspector and Foodstuffs' policy with regards to the range of beers sold by the New World franchisees. As noted in the inspector's evidence, Foodstuffs have engaged a number of times over the last 12 months with regards to the inspector's concerns over the sale of what he views as high-strength, low-cost beer. On the 25th of March 2021, the inspector notified me of the promotion of Rodenbach at New World City Centre in Dunedin. The inspector raised concerns about what he considered to be high alcohol, low-cost beer, including Rodenbach. This was the first time that the inspector raised concerns directly with me. After being notified of the promotion of Rodenbach, I responded to the inspector to notify him that the store had removed the promotion. I also noted to the inspector at the time that this was a rare incident which the owner-operator concerned, who it should be noted is not the applicant, acknowledged was an error of judgment. Later that day, the inspector also raised a concern about the promotion of Rodenbach at Pack and Save Dunedin. Again, as soon as it was brought to my attention, that store was contacted and the promotion was removed. Although the inspector has subsequently from time to time raised his concerns with me regarding the sale of certain brands of beer, as shown in the correspondence attached to his evidence, at no time did he express the view that selling these beers the store concerned was breaching the Sale and Supply of Alcohol Act, which I'll refer to as the Act going forward. Rather, and as shown in the correspondence, he simply expressed his disappointment that they were being sold and tried to cajole us into not selling them. The inspector in his evidence says I have stopped responding to his emails. This is not correct. In addition to the email correspondence attached to the inspector's evidence, I've had telephone calls with the inspector. This included a call on the 5th of November 2021, where I had a conversation with the inspector regarding his views on what he described as high-strength, low-cost beer, and in response to emails he had sent to me on the 4th of November and the 5th of November 2021. During our call on the 5th of November 2021, the inspector reiterated that he did not like the sale of what he called park bench beers, i.e. high alcohol, low cost beer. He asked if I could arrange a meeting with other retailers with the purpose of agreeing to raise the price of that range of beer. I had to point out price fixing, which this would be, was a breach of the Commerce Act and such a meeting could not occur. He acknowledged he had not thought of that. Foodstuff's view is that it is able to supply its franchisees with the beer products in question for them to sell to the public under the Act, provided the sales are made in accordance with the Act, that is, not to minors or intoxicated people, and only within the hours and other terms of a valid off license. Specifically, those products meet the definition of beer in the Act, which a supermarket or grocery store is able to sell. Furthermore, there is nothing in the Act to say that the sale of high alcohol, low price beer is in itself a breach of the Act. I outlined this to the inspector when we spoke on the telephone. I also pointed out it was any change to this was a matter for Parliament. It became quite clear by the end of the call that we were going to have to agree to disagree. Following that call, I received several emails from the inspector about the sale of beer, but in each case there was no suggestion that there was any breach of the Act. Accordingly, I did not see a requirement for any specific action on the part of Foodstuffs. Further, I did not consider that a response was required to every email, as our respective positions have been well canvassed in our call in November, and the inspector had not raised any new issues. I would also like to note that for the email on Monday, the 29th of November, I was on leave that week, and the inspector would have received an out-of-office email from me in that regard. With respect to the December emails, as noted above, there was no suggestion the Act was being breached, and as the matter was now before the District Licensing Committee, I didn't believe it was appropriate to respond. The inspector quotes Mr. Anderson, the now former CEO of Foodstuffs South Island Limited, in his statement of evidence to say, quote, "Foodstuffs constantly analyses its actions to ensure it is a responsible seller of wine and beer." The inspector goes on to say that Foodstuffs is not a responsible seller of wine and beer. Foodstuffs stands by Mr. Anderson's statement. It should also be noted that the types of beer the inspector is concerned with are commonly sold by grocery stores and liquor outlets across the South Island, not just Foodstuffs franchisees. Therefore, presumably by the inspector's standards, there would be few if any responsible sellers of wine and beer. While the inspector may not like high-cost, low-strength beer, as it is clear and seems to be accepted by him, that does not in itself make them illegal. In their statements, the inspector has referred specifically to the following 6 beers as being high-strength, low-cost that are the source of his concerns at the store. Siberian Crown Lager, El Diablo Extra Strong, Royal Dutch Post Horn, Royal Dutch Premium Strong, Folsom Cold Filtered Brew, Bavaria 8.6 Black. The above 6 beers are only a small portion of the beer offering at the store. As a supermarket, and in particular one operating under the New World brand, the focus is on range and therefore customer choice. On this basis, the store stocks a wide range of different beers, including an extensive range of premium and craft beer. Individual franchisees do have some discretion into what range of beers they sell. However, Foodstuffs does have an A range of products that each franchisee is expected to stock. This is to ensure that customers get a similar high quality shopping experience at any one of our franchise New World stores. A range products are deemed to be essential to a banner group, such as New World, and form the basis of a range that would cover most categories and needs of customers. They're products that customers would expect to be found on supermarket shelves and usually high volume and or high sales, as well as being supported by media and promotions. This is important as range is the basis on which the applicant competes with other supermarkets and for the loyalty of customers who prefer to shop at New World supermarkets. Foodstuffs does not mandate that franchisees stock all A range products, but stocking the A range products is measured as a KPI, and our members are expected to stock that range as part of their commitment to the cooperative. Stocking A range products is also a factor that is taken into account with regards to future opportunities to own stores in the cooperative. In relation to the 6 beers that the inspector has referred to, only the Bavaria 8.6 Black is an A range product.
Thank you, Mr. Sullivan. Others in the room, the committee and others may have some questions for you. So if you could just answer those, that would be great.
You want to start here?
No, not really. No, I'm fine. I've got to think about it.
Mr. Sullivan, can you indicate to me, you've said a couple of times of evidence that Foodstuffs ask or require certain ranges to be stocked within product selection. It's expected to be stocked from A range, but you don't penalise them other than through the measure of KPIs. Is that correct?
Yes, in general, it's not an issue we generally have. All our owners understand that by stocking A range, that is, as I said in the evidence, one of the methods by which we give a good customer experience. So I don't, to the best of my knowledge, we've not had a situation where we've felt an owner has so neglected A range as to cause us a major issue. But yes, that's the principle. It's sort of, in some respects, I'd say it's self-policing, because it's in the owner's best interest to stock A range, because that's the products we have found through years of experience that our customers expect to see.
I don't want to jump to the evidence that I've read from the applicant's owner, because he makes comment around the range, but I'm sure it was said in the introduction by the council that the owner is considering the 2 remaining products that are causing the debate in this hearing. Did you hear that at the start or not? Yeah, I don't think you were.
No, I didn't.
Okay, well, let's accept my statement as fair. It can be challenged later, but for your benefit, the owner we've had information suggested, not evidence yet, because we haven't taken the applicant's evidence, but that he's considering, or they are considering, the 2 products. What penalty, in the view of Foodstuffs administration, would you have if in fact he chose to stand those 2 products on one particular side? Because there's 4 have already come off range or selling out, and there's just the remaining 2 that are under challenge, isn't it?
I'm sorry, I'm really having difficulty. It's really echoey. Was there a question there?
Yeah, I thought there was, but I'll try again. Accepting that I've indicated to you that in the lawyer's opening, and having read the applicant's evidence that you have been privileged to hear by way of the hearing, there's an indication that he is considering the further status of the 2 brands, or the 1 brand now in particular, that's remaining to be causing the argument for this hearing, or the basis of this hearing. Can you tell me from Foodstuffs, other than the KPI penalty, is there any other disadvantage to the owner should he choose to take them off shelf?
Disadvantage, I guess the two concerns would be if the range is advertised as part of our A range and we say it's in store and then it's not in store, then that's not a great customer experience for the owner, because people will presume if we advertise something as for sale in New World, it will be there. So there would certainly be a disadvantage there. And if a customer felt that they weren't being that they couldn't find the products that they thought they should be able to find, they will shop elsewhere. So that's probably the big issue or the big disadvantage.
Okay, thank you. Okay.
It's hard to separate out the two bits.
You can't take it.
No.
No.
I just have a bit of a unique situation because the committee have cross-examined the witness. Normal practice would be for me to invite the agency to cross-examine on that component of evidence. My feel is that I would like to take the applicant's component of evidence and then have the parties cross-examined. Mr. Sullivan, are you going to remain available to us for a period of time this morning?
Yes, I can do.
Yeah, so I think that's a more practical way because there is a question on the procedure that's been asked of me. So I would like to park Mr. Sullivan's component at the moment, but have the ability to recall him into cross-examination a little bit later in the process. Are you comfortable with that, Ian?
Well, I suppose I'm comfortable with it. I don't quite see the rationale for that. It seems to me Mr. Sullivan's evidence is quite narrow in its scope and questions about it could be asked now so that we wouldn't have to keep him potentially coming back later. But of course, the committee has the opportunity to recall any witness, and it sounds like Mr. Sullivan is available for that. So we can proceed that way if you would like.
Yeah, the component would be that after we take Mr. Broderick's evidence, I then will open up for cross-examination on the applicant's presentation, both by the panel and by the agencies if they wish to proceed at that point. So we need to, I'm trying to keep the package as tight as I can, but on Mr. Sullivan's availability, I think I prefer to continue and take the second component of the evidence and then have cross-examination on it all.
Understood. Thank you.
You heard me say there's a couple of references I tried to make to Mr. Sullivan about Mr. Broderick's evidence because they actually run together. So the package together, I think, would make more sense.
Understood.
Thank you. So Mr. Sullivan will stand to your side for the moment and return to you likely a little later.
So would you like me to stay on the call or will someone contact me and ask me to come back in?
If you have time, you're most welcome to stay, but Mr. Broderick's evidence is not long in quantum, so I think if you could stay with us, it may be more complete to run it together.
Okay.
All right.
Yep, certainly.
So Mr. Broderick is the next witness.
Thank you, sir. So, Mr. Broderick, do you have a copy of your statement with you?
Yes, I do, thank you.
And sir, the starting point would be for Mr. Broderick to have an oath or affirmation administered to him.
Yeah, thank you. We'll do that from here.
Mr. Broderick, do you confirm by oath or by affirmation?
Oath, thank you.
Do you, Craig John Broderick, swear by the Almighty God that the evidence you are about to give shall be the truth, the whole truth, and nothing but the truth?
Yes,
Thank you.
thank you.
So, Mr. Broderick, if you could start reading your statement, please. Just start right at the beginning, paragraph 1, and go from there.
Okay, thank you. So my name is Craig Broderick. I am director of Basneath Limited, the applicant. The applicant owns and operates the New World Gardens supermarket business store from premises situated at 6 North Road, Dunedin, the premises. The applicant operates the store under a franchise agreement with Foodstuffs South Island Limited, known as Foodstuffs. I've been in the supermarket business for about 35 years. I started out with an after-school job collecting trolleys and crushing cardboard, and moved my way up through the positions in management, and then finally into a role as owner-operator, along with my wife, Julie. I was the owner-operator of New World Redcliffs in Christchurch for 3.5 years before I became the owner-operator of New World Balclutha. I've been the operator of New World Balclutha for around 10 years. Before my time at Redcliffs, I worked at New World in Palmerston North, Pack and Save in Kapiti, New World in Thorndon, Wellington, and at head office in Wellington as a business advisor to New World Supermarkets. The applicant took possession of the store on the 1st of November 2021 and is currently trading on a temporary authority. On the 7th of October 2021, the applicant applied to the Dunedin District Licensing Committee for a new off-licence for the store application on the same terms as the previous owner's off-licence. The police and the medical officer of health do not oppose the application, and I understand that there are no public objections to the application. However, the licensing inspector has reported in opposition to the application. I understand that the inspector's opposition to the application relates only to the sale from the store of some SKUs of 500 to 1,000 ml imported beers. My understanding is that the inspector considers that the sale of those beers is contrary to the object of the Sale and Supply of Alcohol Act 2012, the Act, and that in selling those beers, the applicant is therefore unsuitable to hold an off-licence. Other than the issue around the sale of those products, I understand that there are no concerns around the suitability of the applicant or the object of the Act in relation to the application. So, the operation of New World Gardens. The applicant takes compliance with the law very seriously, and the store is run in accordance with Foodstuffs policies regarding the sale of alcohol. We have good systems and processes in place for training of staff and ensuring no sales to minors or intoxicated people, as well as compliance with the single alcohol area. As with the other supermarkets that I have operated, we ensure that every new staff member on checkout completes comprehensive induction training in relation to the sale of alcohol and our electronic point of sale systems. In addition, the applicant's staff will undertake refresher courses on alcohol legislation. For example, every 6 months, we will run a refresher program and staff will need to pass a test, and staff will need to pass a test at the end of the program. Excuse me. We are also implementing a policy where all of our checkout,
Just take a moment.
Yep, sorry.
No, just take a moment, because I know what that feels like.
Thank you. Yep. Thank you. We are also implementing a policy where all of our checkout supervisors, currently 13, will need to have their manager's certificate. 8 already have these at the moment. We also have a strict under 25 ID required policy, which requires everyone who looks under the age of 25 to provide valid ID before they can purchase any alcohol. The store's system includes an automatic computer prompt at the point of sale, including at the self-serve checkouts. The prompt advises that a restricted item is being sold and requires the operator to check the customer's identification. The operator then asks for ID, and if the customer is over 18, the operator will call the supervisor to authorise the sale. At a self-serve checkout, the checkout will disable and prompt the supervisor to attend the checkout. The supervisor checks the customer's ID, and if they are satisfied that the sale is compliant, they will approve the sale and unlock the operators or self-serve checkout system, allowing the transaction to take place. If the person purchasing the alcohol appears under the age of 25 and has no identification, then the sale will simply not take place. We also have a strict party rule. So if any person in a group purchasing alcohol looks under the age of 25 and this person does not have ID, alcohol will not be served to the group. Any person who appears intoxicated will be refused the sale of alcohol. Intoxication is assessed by observing appearance, behaviour, coordination and speech. If any of these seem impaired, then staff will refuse the sale of alcohol. Where concerns are raised on the possibility of repeat offending, then trespass notices may be enforced. In addition, the applicant monitors the store with CCTV footage, and footage from this is kept for around 1 to 3 months. This footage assists staff with identifying problem customers when necessary. Excuse me. I can confirm that the applicant has never failed a police-controlled purchase operation in the entire time that it has been approved owner-operator of a supermarket business. As well as police-controlled purchase operations, the store will also be subject to Foodstuffs' independent audit program, where stores are mystery shopped every quarter to ensure compliance with alcohol legislation. The applicant has also never failed a Foodstuffs audit in the entire time it has been approved owner-operator of a supermarket business. As noted above, the inspector has raised no issues with the training of the staff or with systems in place at the store. The inspector's report also notes that there is no concern with noise, vandalism, or nuisance in the vicinity of the store. I was also advised by the inspector that the single alcohol area at the store was one of the best. Neither the police nor the medical officer of health have raised any concerns with the suitability of the applicant or with the application generally. It appears that the inspector's only concern is with the price, size, and alcohol content of a small portion of the range of beer that the store sells. Inspector's evidence. I received on or around the 4th of February statements from the inspector, Anthony Mole, and Nicola Jackson, the Executive Director of Alcohol Health Watch and based in Auckland, setting out the inspector's position, as well as other statements that appear to have been prepared in relation to the liquor store's application for an off-licence in 2017. I have prepared this statement in response. In their statements, the inspector and Ms. Jackson have referred to low-cost, high-strength beer and have outlined what they consider to be the harm that can arise from inappropriate or excessive consumption of these beers. I understand from Ms. Jackson's statements that, in her opinion, low-cost, high-strength beer are beers that have a high alcohol percentage, are sold in single units of 500 ml or more, and are also low cost. Ms. Jackson says that a price of $1.20 or below per standard drink is too low. I understand that craft beers do not fall within the category because, while they might have a similar alcohol content, they are a higher price. In this statement, the inspector has referred specifically to the following 6 beers as being high strength, low cost, and the source of their concerns at the store. Siberian Crown Lager, El Diablo Extra Strong, Royal Dutch Post Horn, Royal Dutch Premium Strong, Balsam Cold Filtered Brew, and Bavaria 8.6 Black. I note the 6 beers above are part of our premium single beers range and only a small portion of the beer offering at the store. We are currently ranging a total of about 600 different beer products at the store. We also range about 1,130 different wine products and 104 different cider products, which are a category of wines, and 1 mead. Like all supermarkets, and particularly for New World supermarkets, our store provides one destination to meet all our customers' household needs, and our focus is on range and customer choice. This is important as range is the basis on which the applicant competes with other supermarkets. If customers cannot find the range they expect from our store as a New World supermarket, they may well take their entire supermarket shopping elsewhere. On this basis, the store stocks a wide range of different beers, including an extensive range of premium and craft beers. Our beer range is sold in a variety of sizes, from single units to 24 packs, and we also stock a larger variety of no or low alcohol beer. In terms of alcohol content, the strength of our beer products will differ depending on the style of beer, but I expect the range to be between 0 to 9%. The majority of our beer range is well below 15% alcohol content. We also stock a wide range of wine and cider, which also come in a variety of sizes and include no or low alcohol products. I expect the range of alcohol content for wine sold at the store to be between around 0 to 14%, and for our cider to be between around 0 to 8%. Further, as a New World, the store generally offers less discounts than other supermarkets. While we are always well priced, New World is not known for competing mainly on price, as opposed to other aspects of the shopping experience like range and quality. Whereas Countdown and Pack and Save are, sorry, just excuse me. In relation to the 6 beer products referred to above, the applicant has already made a commitment to delete some of the products from its range. I made that commitment on behalf of the applicant in my email to Kevin Meakin on 9th of December 2021. However, as set out in that email, there is one product that is part of the New World Group range, and which the store is meant to stock under its franchise agreement with Foodstuffs, and there is also one product that I advised I would consider. I've set out an updated summary of the status of the relevant products below. So currently, Siberian Crown Lager is being deleted and is not on the shelf. El Diablo Extra Strong has been deleted and is not on the shelf. Royal Dutch Post Horn is deleted and currently selling through the stock. Royal Dutch Premium Strong has been deleted and there's no stock. Balsam Cold Filtered Brew currently in stock. Bavaria 8.6 Black currently in stock and ranged with the New World Group.
Mr. Broderick, can I just interrupt there to ask you a question, please, about the first item in your table at paragraph 32 of your statement?
Yes.
When you read your statement, you said that Siberian Crown Lager is no longer on the shelf.
Yes.
Is that right? You've now sold through the old stock?
Yes.
Thank you. Yes, if you could carry on.
I may just, yes. Oh, sorry, currently selling through. Yes, it's on the shelf and currently selling through.
So there is still some
Yes.
of that left.
Yes, there is.
Do you have any idea of how much there is to go?
From memory, I think it should about 10 units left.
Thank you, Mr. Broderick. If you could carry on, please, from paragraph 33.
Thank you. I note that at paragraph 16 of his statement, The inspector refers to the meeting we had at the store on the 4th November 2021, and he says that I conceded that the reason people only buy cheap beer is to get intoxicated. I note that I did not concede or agree with the inspector's opinion. As I repeated in my email on the 9th of December 2021, I told the inspector that I could not agree or disagree with his opinion, as I did not have any evidence that those products were causing harm. However, I still made the commitment to remove 4 of the 6 beers that the inspector pointed out on his visit on the 4th of November 2021, and that he later raised as a concern in his opposition report. I believe that I have been open to listening and responding to the inspector's concerns about those premium single beer products, and I arranged for changes to our range as a result in good faith. It was only later that I heard that the inspector had opposed the application. Ms. Jackson's statement refers to the harm related to young people purchasing alcohol, and in particular, young males purchasing beer. The applicant does not have a record of the age of all customers that visit the store. However, we do have access to some New World Club card data for this month that contains some age information, although for privacy reasons, details cannot be released. At a high level, and noting that club cards are not held by all of our customers, for the Folsom Cold Filter Brew product and the Bavaria 8.6 Black product, that data shows that the age range for customers purchasing those products was between 20 and 70 inclusive, and around 67% of sales were to customers aged 25 and over. The data reflects my understanding of our customer base, as although there are certainly students that live in the area, we get a real mix of customers, with many being families, older residents from the area, and young professionals. I expect students to make up approximately less than 10% of our turnover across the whole store, based on seasonal turnover fluctuations when students return to the city. I understand from Ms. Jackson's statement that she is concerned with these beers being consumed immediately, including consumption nearby in public spaces such as parks. Ms. Jackson also refers to young people preloading on these beers before going to unlicensed premises. As referred to above, our store is a one-stop shop, and a good proportion of customers purchase alcohol with their other groceries and as part of their overall shop. Our store sells grocery foods first and foremost. In this way, the store is very different to a liquor store and generally attracts a different customer base. The liquor stores sell products such as spirits and ready-to-drink alcohol products that our store cannot. As noted above, sales of the products the inspector has concerns with are not just to students or young people. The customer age varies, and to date, I've not seen anyone drink these products in a nearby public place or in our car park. No issues with that kind of behaviour have been raised by the police to my knowledge, and my own personal observation while driving through the student area is of seeing students carrying a box of RTDs, a 12-pack of Spates cans, a box of spirit mixes, and empty spirit bottles outside flats on the footpath. The inspector has also referred to an email of 8th November 2021 in which he said he would like to get an idea of sales data at the store. I did not reply to this because extracting sales data is difficult. The request was very broad and disclosure involves privacy issues and commercially sensitive information, and there are limitations to the data that is available. I note that the premium single beer range is sold as single units, but other types of beer sold at the store are not. Therefore, it is difficult to compare those sales with multi-pack units. For example, purchasing 2 singular units of beer will contain less alcohol than a 6 or 12-pack of beer. Our sales data does not break down the cost of alcohol per standard unit.
Mr. Broderick, can I just stop you there?
Yes.
Mr. Chair, what Mr. Broderick's about to go into contains a little bit of data about sales in the store, and that is obviously confidential data and may have some commercial sensitivity in the fact that this store obviously competes with other supermarkets. So in the normal course, I would ask at this stage for a direction from you that the content of that data is kept confidential. And if we are currently on YouTube, I'd ask that we are disconnected from that while Mr. Broderick goes through the data. So there are two requests: a confidentiality order in respect of this data so that no one may report it or release it outside of this hearing, and for that purpose, turning off the YouTube connection.
Well, thank you for that request. Just give me a moment, thanks.
No, you're muted. Oh, sorry, you're not.
Paul? Right, I'm going to give a directive in a moment in reply to the statement that's been made to me, or request that we will go offline and the information is restricted under the Act. So I need to record the statement online, but then when I get to the end of it, I go off. You just hang on, I just need to.
We're recording. We are recording. So this is separate to YouTube. Paul will turn off the live stream.
Okay. Yeah, Paul, if you can take the live stream down, please, and I'll give you an indication when we're returning. Thank you. The committee has just taken the final statements from Mr. Broderick, and now we have an opportunity for the committee to cross-examine the applicant's presentation across its content. So we need Mr. Sullivan to come back in case there are questions directed to him. Mr. Sullivan, you with us?
I can hear you. I'm not sure you can see me though.
That's okay. We can take it if because of the internet the stability is challenged. We'd certainly rather have your quality voice. We can see that you're live on the screen. Just the photograph or the picture is missing at this stage. So I'm going to now invite my colleagues to have any cross-examination of the applicant's presentation to this point. Karen?
I haven't got any questions. I'm sorry. I don't have any questions at the moment. Thank you.
Okay.
Both. Mr. Broderick, I've got a few questions in regards to the date ranges in which you collected the data. I'm cognizant that this month the students have only just started coming back into Dunedin, and wondering if that may have influenced the sales, and if you've compared this month's sales to similar times in previous years.
No, I haven't. I took for the half hourly, the 2 weeks, I did that to try and include some sales from the students. And the 13 weeks is from the last complete week, and it's just a standard report we use to look at sales data. And that's why I used that report in that time period.
Thank you. That's, from my point of view, there is obviously an influx of younger people that come in, which impacts Dr. Nikki Jackson's evidence, and I understand that we can't have that information readily available, given they're still coming through into the city now. In terms of your decision to make some of the lines deleted, is there an assurance that you will not be bringing those lines back into play?
Yep, they won't. I won't bring them back in.
Thank you. One of the other factors that you spoke about is how you will, prior to South Island, providing a range as opposed to primarily a discount type way of attracting customers. Your council identified one of the products, Folsom Cold Filtered Brew, was below the $1.20 per standard unit price due to it being on special. Is there a common occurrence that those types of alcohol are reduced in price?
Yes.
Just there, I'm afraid I didn't hear the question properly. The connection broke down on that, so I don't know whether Mr. Broderick has answered the same question that you asked. So I wonder if you could repeat that question.
The question in essence was, is it common for the products identified by the inspector to be discounted, given your statements? The only reason it was under $1.20 per standard unit drink was that it was on discount at the time the inspector purchased the drink.
So yes, that's correct.
That's all from me at this point.
Gentlemen, I just have one question, Mr. Broderick. You've indicated in evidence, paragraph 26, that you have 600 different lines of beer. Well, I'm a great believer we learn something new every day, so that's a significant number. We're talking particularly an objection to a product that sells, you indicated to me the number, a very low percentage. Have you advanced your considerations with regard to that particular 2 lines?
So the Bavaria, I can't take off the shelf. That is part of my franchise agreement. And if it was advertised and I wasn't stocking it, my understanding is I'd be in breach of the Fair Trading Act. by advertising something and not stocking it. So I can't take that product off the shelf. The other product I have left on the shelf, excuse me, as the sales were, I'll say good, not great, but good. They weren't slow. So I've decided to keep that product on the shelf as from a customer's point of view, customer satisfaction.
Thank you.
Sorry, Mr. Roderick, I've got just one other question in regards to one of the lines that you have deleted but are currently selling through. Similar to the question Mr. Thane asked, how many units do you estimate to be left of the Royal Dutch post-horn beer?
From memory, I think I have around 20 units.
Thank you.
Mr. Broderick, I've got a couple of questions. It's really to do with beer, and I'm hopeless because I don't drink beer, and I was really quite surprised at the price per standard drink, or the price overall, and the number of standard drinks that are contained within some of those beers. I guess I just wanted to know if you're stocking the Bavaria 86, I understand that you have to keep it, but the Fulsome cold filtered brew, will you still be running specials on that beer, seeing as you're going to keep stocking it? Will you still be running specials on it so that it is underneath that price that we were talking about before?
So currently at the moment, I intend that will still happen on promotion. Yeah, that's currently at the moment.
Are those promotions New World promotions or just your promotions for cheaper price?
So on that Folsom, that is our promotion.
So theoretically, you don't necessarily have to run that promotion.
No.
Okay. Just bear with me for a minute.
No.
Is that beer in the fridge or is it just on the shelf?
In the fridge.
Right. So that's one of the indications from Dr. Jackson's evidence, that it is more of an invitation to drink it pretty quickly and almost immediately if it's in the fridge.
Yes, that's in her evidence. Yes, correct.
Yeah. Okay. So beer, I understand that beer is considered to be high strength at above 5% alcohol. Is that your knowledge as well?
Some beers are, and some are below.
Some high strength beers are below 5%.
So we talking the premium singles, I take it, these 500 ml cans.
No, sorry. What I'm saying is from my research and reading the research that came through, that beer in general, any beer, is regarded as high strength if it's over 5%.
Oh, I'm sorry, I'm unsure. Yeah, I'm not sure what the line is.
Okay.
Put it as high strength.
Right. All right, thank you. I don't think I've got anything more at the moment.
Thank you.
All right, from the applicant, anything further you wish to add to your presentation this morning?
No, thank you.
Can I just ask Mr. Broderick one question arising out of those questions that the committee asked?
Of course.
Hopefully only one. Mr. Broderick, you were asked a question about whether that Fulsome product sits on the ambient shelf or in the fridge, and you said it's in the fridge.
Yes.
You sell bottles of wine in the fridge as well?
Yes.
What's the alcohol content of a bottle of wine?
So around 12, 13%.
And standard bottle of wine, 750 millilitres?
Yes.
Yes, so the total number of standard drinks in a chilled bottle of wine sold in your fridges would be more than in the fulsome product. Is that right?
That's probably correct.
And in selling wine that way, are you at all unusual amongst supermarkets?
No, that's very standard practice.
Thank you, Mr. Broderick.
Thank you. Let's just take a moment, please. Mr. Mole, we now would give an opportunity to yourself to do cross-examination. Are you in a position to proceed with that?
No, sir. I seek time to be able to assess the evidence provided on Friday afternoon and this morning.
Is it fair for me to indicate that the evidence of both applicants' witnesses had been read in detail this morning?
Yes, they both read it out, yes.
And one contains 5 pages and 26 points. The other contains 11 pages and 42 points.
If you say so, sir, yes.
Right. The next question then, Mr. Mole, is obviously we're having to consider your request for a procedural delay or deferment or adjournment. To quantify that, you're aware of under section 207 in the Act, the direction the committee has to proceed on evidence.
I'm happy for you to read that out, sir.
Well, you're well versed in the Act. It clearly says that the committee can make whatever decision it sees on receiving the receipt and proceeding on evidence. And that's something we need to consider in light of the balance of evidence given today. The other balance as part of the procedural delay is that I'm concerned that Dr. Jackson, as your witnesses, has been sitting through a period. So are you asking, can you explain to me what you're asking by way of an adjournment? Because then the committee will reconsider your request. Are you asking for a delay today or a reconvening period? Or what are you specifically asking for?
I'm seeking that the hearing be adjourned today and reconvened at another date.
From your knowledge of the Act, what delay period or what period of notice does the committee have to give to reconvene?
I'm not sure that, sir, but if we look at the practice note requires those 5 days, so I think re-adjourning next Friday would be appropriate. Right,
the committee is going to adjourn for 15 minutes. I need to make it a worthwhile period, so anyone can go and have a coffee while we consider whether we continue today. But you're confirming, Mr. Mole, that Dr. Jackson is available and has been sitting through the hearing and is available to us today?
Dr. Jackson is nodding, so yes, sir.
Is your objection, so I clarify this quite clearly, to not being able to cross-examine the applicant, would you consider continuing to give your evidence and Dr. Jackson's with a reserved right for your cross-examination?
No, sir, I would prefer the general procedure for hearings to go ahead. The applicant goes first and is subject to cross-examination, and then the reporting agencies go through the same process.
The Act does allow for variance to process, though, doesn't it, Mr. Mole?
My preference is to continue as the standard practice.
I didn't ask you, sir, your preference. I asked you, does the Act allow? Because my reading of the details suggests the discretion is at with the committee.
Well, I would like to seek further advice on that point then, sir.
Okay, we stand adjourned for 15 minutes. Paul, can you take us offline? Oh, sorry, before we do. Sergeant Jones, Is it your intention to cross-examine the applicant's evidence?
Yes, sir, I do have some points for cross-examination, and I would like to emphasise my lack of prep due to disclosure as well. So, but I would like to have some ability to cross-examine.
That right is there. I'm just checking on your position. Right, we stand adjourned for 15 minutes. Thank you. Thank you, Paul. All right, thank you. I think all parties are back with us. The committee have considered and to obtain a secure position, we have two things to indicate. Our proposal is, or our preference is, to reconvene on the 1st of March at 10 a.m. And the second is that to the applicant, the TA that is due to expire on the 1st of March will be extended for an appropriate time so to continue trading. We have the ability under the Act to provide an extension, and practically we need to do that. But Mr. Mole, the question then becomes the availability of your witness.
That was the 10th of March?
No, 1 March, 1st of March.
Oh, 1st of March, sorry.
Tuesday the 1st of March.
Yes, absolutely fine.
Fine. Mr. Mole? He's okay. To the applicant now, we need to, it's not a bit of a Dutch auction, I'm not trying to do that, but you just need to try and get a general confirmation we're in position.
Thank you, sir. Our preference, as you know, would have been to continue today. But I take it that you're not looking for submissions from me seeking to change your view on your preference being to adjourn?
No, it's not. The committee's taken some advice, and I'm very clear to obtain a secure position, and that's what we need to give you confidence, whatever the decision will be, that it's a secure process, that we do it on the 1st of March at 10 a.m.
Thank you, sir. That's understood. So on that basis, then, Tuesday the 1st of March is okay for us. And I would just ask Mr. Sullivan to confirm whether or not he will be available that day in case he's required for some questioning.
I understand that.
Yes, I'll be available.
Right, and Sergeant Jones?
Yes, sir, I'll be available.
So, Mr. Mole, we have a position that you now agree with and support.
Yes, sir.
Thank you. Thank you for raising it. It's a practical experience to have. Not had easy because of Skype, but we'll come back in on a Skype service on the 1st of March, 10 a.m. Thank you for your attendance today. You stand adjourned.
Thank you, sir.